Are DUI checkpoints legal in Michigan? Most drivers assume that sobriety checkpoints are a standard part of law enforcement everywhere, but Michigan operates under a fundamentally different set of constitutional rules. Michigan uses the term OWI, which stands for operating while intoxicated, and governs impaired driving charges under MCL 257.625, rather than the more commonly known DUI label. The Michigan Supreme Court found suspicionless sobriety roadblocks unconstitutional under Article 1, Section 11 of the state constitution, giving Michigan drivers stronger protections than the federal Fourth Amendment provides. While federal law permits properly conducted checkpoints and the U.S. Supreme Court upheld them nationally, Michigan courts concluded that stopping every driver without individualized suspicion was too great an intrusion on personal liberty. This means that unlike many other states, Michigan law enforcement cannot set up roadblocks on public highways and stop vehicles in a predetermined pattern without any specific reason to suspect a driver. However, the absence of checkpoints does not mean officers in Oakland County or anywhere else in Michigan are powerless to make OWI arrests. Police can still initiate a lawful traffic stop whenever they observe specific, articulable facts pointing to a possible crime or traffic violation, a legal threshold known as reasonable suspicion. Swerving between lanes, running a red light, or driving unsafely in any observable way can give an officer sufficient grounds to pull a driver over and begin an OWI investigation. Once a driver is stopped, officers look for signs of intoxication, such as the odor of alcohol, slurred speech, bloodshot eyes, an open container, or poor performance on field sobriety tests. To move from a traffic stop to an actual OWI arrest, the officer must establish probable cause, a higher legal standard based on the totality of observable facts during the encounter. During any traffic stop, Michigan law requires drivers to present their license, registration, and proof of insurance, and refusing the post-arrest chemical test can trigger a license suspension and 6 points on your record. Michigan drivers who travel to other states should know they may encounter sobriety checkpoints there, and the rights that apply will be governed by that state's law rather than Michigan's constitutional protections. A skilled attorney can examine the officer's stated reason for any stop, compare it against police reports and recorded evidence, and determine whether the stop or subsequent arrest can be legally challenged. The law firm of Paul J. Tafelski, Michigan Defense Law, defends drivers throughout Oakland County facing OWI charges by reviewing the legality of stops, addressing test results, and responding to license and court consequences. When your driving record, your freedom, and your future are on the line, having an experienced lawyer by your side to scrutinize every detail of your case can make all the difference. Contact Michigan Defense Law, located at 2525 S Telegraph RD Suite 100, Bloomfield Hills, Michigan 48302, by calling 248-451-2200 to speak with a dedicated attorney and schedule your consultation today.